So we had 36 teams this year at the 18th Annual Civil Rights and Liberties Competition, and our two finalist teams, who I'd like to welcome to the stage right now, are Team 77, representing the petitioners, and Team 670, representing the respondent. Additionally, as our competitors are making their way up, I would like to introduce our three final round judges who we are honored to have today to observe our final round. Our first judge is Judge Beverly Martin, who has served 21 years as a judge in the United States courts. The U.S. Senate confirmed Beverly as a judge on the U.S. Court of Appeals for the 11th Circuit in January of 2010, where she served until September of 2021. Beverly served until this year as the executive director of the Center on Civil Justice at NYU Law School. Before taking her oath as a U.S. judge, Beverly served as the United States Attorney for the Middle District of Georgia, as well as an assistant U.S. attorney in that office. She represented the state of Georgia between 1984 and 1994 as an assistant attorney general in Atlanta. Beverly received her JD from the University of Georgia School of Law. Our second justice today is Judge Victoria Calvert, who began her practice of law at King & Spalding's Atlanta office, where she served as an associate on the firm's Special Matters and Government Investigations Group and defended organizations under investigation for potential violation of federal criminal laws. While at King & Spalding, Judge Calvert also devoted thousands of pro bono hours representing two individuals who were under death sentence in Georgia. 5 years later, Judge Calvert joined the Federal Defender Program as a staff attorney, where she represented hundreds of individuals charged with violating federal laws in the Northern District of Georgia. In 2022, Judge Calvert was nominated by President Joseph R. Biden Jr. and confirmed by the U.S. Senate to serve as a district court judge for the Northern District of Georgia. She took her oath of office on April 5, 2022. Judge Calvert is also the first former public defender to serve as a district court judge in Georgia. Our final justice today is Zach Greenemeyer. Zach leads Mitchell Shapiro Greenemeyer and Fund LLP's civil rights practice, representing plaintiffs in constitutional litigation involving government misconduct. Some representative cases of his include First Amendment challenges to unlawful government silencing of free speech, and advocating for those who have been falsely arrested or imprisoned and who have experienced serious, excessive, and illegal force. Mr. Greenemeyer was also selected as a top 40 under 40 trial attorney, as a super lawyer rising star, and as an attorney on the rise by the Daily Report. Mr. Greenemeyer was named the Southern Center for Human Rights 2024 Justice Ally of the Year. Mr. Greenemeyer is a graduate of Harvard Law School, where he served as editor-in-chief of the Harvard Civil Rights Civil Liberties Law Review. We're going to go ahead and welcome in our final judges and begin our final round.
Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near to the court is now sitting. God save the United States and this honorable court. The first case on the calendar is Dante and Tony Fitzgerald, individual, parents of their child, Gloria Fitzgerald, the city of Pittsburgh. The Honorable Chief Justice Calvert and Justice Greenemeyer are presiding.
Petitioner stands ready.
Counsel for respondent ready. Yes, ready. The Honorable Justice is ready.
We're ready.
We're ready.
Petitioner, you-
Madam Chief Justice, may it please the court. My name is Carson Winnicky, and alongside my co-counsel, Museret Rahman, We represent the petitioners, Dante and Tony Fitzgerald, in the present appeal. Chief Justice, at this time, petitioners respectfully request 2 minutes for rebuttal. Thank you, Your Honor.
That's fine.
There are 2 issues for the court's consideration on review, and I will be addressing the first. Demonstrating the right to companionship does not cease until a child assumes critical decision-making responsibility. My co-counsel will address the second issue, and she will demonstrate that the City of Gutenberg's failure to train its permit officer constituted deliberate indifference. Your Honors, this court should reverse the 14th Circuit's decision on the first issue for the following 2 reasons. First, age is not the exclusive determining factor in expanding substantive due process rights. And second, the 14th Circuit failed to conduct the factual analysis necessary here to ascertain whether Dorian Fitzgerald had assumed critical decision-making responsibility at the time of his death.
So is that what you're really asking us for, to remand for further factual development?
Yes, Your Honor, that's exactly what was necessary here, was to conduct the factual analysis to ascertain whether Dorian Fitzgerald assumed critical decision-making responsibility.
If you had to pick an age that we kind of start as a guideline with, what would that be?
Your Honor, it would be 18. We would ask this court to adopt the test from the Third Circuit in McCurdy versus Dodd, where the age of majority, here for the state of Genovia, as indicated at record page 5, note 1, is 18 years old. The way that that presumption functions in practice, Your Honors, is that once a child reaches the age of 18, the presumption works against the parents. However, Your Honors, in practicality, the parents should be afforded the opportunity to proffer evidence that a child has not assumed critical decision-making responsibility. And the converse is also true for parents. If their child is under the age of 18, the presumption works against a municipality because a municipality can still demonstrate evidence that a child under the age of 18 has assumed critical decision-making. And Your Honors, that test is not unfounded in this court's precedent. This court in Stanley versus Illinois emphasized that a substantive due process right, like the right to companionship, custody, and control of a child, can be expanded in particular circumstances. And what Stanley relied on was this court's precedent in Pierce versus Society of the Sisters, where the state law at issue in that case involves students ages 5 to 21 whose parents challenged the educational curriculum regulation in their schools. What this court did not do in that case, Your Honors, is cabin the scope of a parent's liberty interest only to the children at issue of 18. Rather, this court emphasized that so long as a parent can demonstrate that they exercise control over their child, that is sufficient to warrant an extension of a substantive due process right.
What did you think of the analysis that the Ninth Circuit did in the Sinclair versus City of Seattle case? Should that be helpful to us?
Yes, Your Honor, the City of Sinclair versus City of Seattle is helpful in this case because it functions and it demonstrates how the presumption from McCurdy versus Dodd in the Third Circuit works in practicality. Respondent will likely tell this court that it's a categorical distinction, that it expands this right amorphously. However, Your Honors, we would point to the case trends since the City of Seattle enacted the right to companionship on a totality of the circumstances approach. And in the Ninth Circuit, since enacting that decision in 2023, only 5 cases have brought claims dealing with an adult right to companionship. And in each of them, the Ninth Circuit has denied that right. However, what was necessary in those cases was that the court permitted the parents to proffer evidence that a child has not assumed critical decision-making responsibility. And Your Honors, at a minimum, going back to Justice Martin's earlier question, at a minimum, that's all the petitioner asks for, Your Honors, is the opportunity in the trial court to proffer evidence that Dorian Fitzgerald, as the 14th Circuit acknowledged, the only difference between him and his classmates was his age.
If I may, you're talking about recent developments, which is somewhat problematic. Do you agree with the city's premise that we must look to see whether this right was deeply rooted in our nation's history?
No, Your Honor, because the distinction that this court pulled in Dobbs versus Jackson Women's Health Organization is the difference between an extension of an existing right and the creation of an entirely new one. The test that the petitioners ask for here is not the creation of an entirely new right to companionship. Rather, we are asking for the extension of that right.
Okay, but can you direct us to any historical evidence about that right, whether extended or as it was at either the founding or at the adaptation of the 14th Amendment or the KKK Act?
Yes, Your Honor, this court should look to Troxel versus Granville, where this court walked through the analysis of Western civilization and the nurture and nature of the parent-child relationship. In Troxel, what this court emphasized is that substantive due process rights are inherently fluid. However, they are not limitless. What's at the core of a parent-child relationship is a fundamental liberty interest, and thus a court should be cautious to cabin the scope of that right in circumstances where it is not necessary to do so. Going back to our earlier discussion, Your Honors, Pierce demonstrates the historical significance of the right to companionship. In that case, this court chose not to cabin the scope to an 18-year-old age of majority on a substantive due process right. And in its reasoning, it emphasized, because the right of a parent in their relationship with their child is so fundamental and so historically recognized that constitutional protections should be extended when those protections are warranted. And Your Honors, those protections are warranted here because at the core of our nation's history and foundation is the familial values that form the basis of Western civilization. Here, although this court has not explicitly recognized the right to companionship between an adult child and a parent, it is not explicitly held to the contrary. Rather, this court in Stanley left the court open to particular circumstances, and as evidenced by the plaintiff's complaint, as indicated at pages 22 through 26 of the record, this is such a particular circumstance, Your Honors. We are dealing with a high school senior who takes the school bus to and from school, who resides in his parents' care. That is fundamentally different than a child who has exceeded the bounds of their home, has had the opportunity to exercise their independence, and we don't see those facts here. Further, Your Honors.
Do we see any, I'm with you to a certain extent that obviously this is an important relationship that the state protects in some, or our country protects in some circumstances. But what evidence is there that anybody did anything with any intent to interfere with that relationship besides make boneheaded decisions, right?
Your Honor, this is a far cry from a boneheaded decision when we trace the city of Gutenberg's conduct in this particular circumstance, and my co-counsel will address this more specifically within her argument. However, what is clear is that the city's direct failure to train its permit officer in exercising her broad discretion resulted in the direct deprivation of the right to companionship. Further, the permit officer's conduct here placed a protest outside of a high school as students were released within the day from the class day. Your Honors, that's important for multiple reasons, because as the 14th Circuit recognized at page 11 of the record, the only difference between Dorian Fitzgerald and his classmates was his age. We see no indication that Dorian Fitzgerald had critical decision-making responsibility at the time of his death. And that's exactly why this court should reverse the 14th Circuit's decision, that adopting this test here does not result in floodgates of litigation, but it also complies with this court's precedent in Stanley, where it articulated that the ever-changing circumstances and the abnormal dynamic between a parent and child warrant those extensive protections.
What do you define as this right? I mean, what would be the scope of it? When would it end? What is it?
Your Honor, it would cease when a child has resumed independence, and we can look to the circuit courts for a more specific indicator of what that looks like in practice. For example, the D.C. Circuit in Batera versus District of Columbia held that a child did not have a relationship with their parent and thus no liberty interest claim because the child resided out of the home, resided in a different state. He was 31 years old, not financially dependent on his parents, and also had a family of his own. In practice, that's what this test would look like. It doesn't automatically grant a parent an amorphous liberty interest in their child. Rather, all it allows parents to do is proffer evidence that their child has not assumed independence or not is otherwise emancipated. Further, Your Honors.
Are there other factors that I mean, I think those are helpful factors to observe, but are there other factors you think we should, if we were to remand it, that the court ought to look at?
Yes, Your Honor, and that does come from the Batera case. The court considered financial independence, where the child resided, who the child resided with, what their family composition looked like, and what the historical education of that child was. For example, the court called attention that if we are dealing with a college student that resides outside the home, that would be a different question because it is a child that has indicated some intention of independence. Further, Your Honors, when we look to the policy reasoning of holding for the petitioners today, a United States District Court in Laureano versus Gord emphasized that adopting the test we ask for here does not expose municipalities to endless liability. Rather, it extends liberty interests only to those parents who can demonstrate that they have retained the right to control. And that is directly in line with this court's fundamental precedent of recognizing that a parent.
So I want to go back to the Chief Justice's question. Like there are maybe two strains to this right that are in controversy, the age part and then like the substantive or like what variety of conduct does this apply to? And I'm having trouble seeing how there are any limits to this. Like, you know, if something bad happens to a kid, obviously that is terrible, but that doesn't mean that that is a constitutional violation necessarily. Where do we draw lines there? Because, you know, that seems very hard, and we need some guidance from you.
Madam Chief Justice, I'm out of time. May I answer the Associate Justice's question?
You may.
Thank you, Your Honor. The contours of this right are defined by the presumption in McCurdy. We acknowledge that at the age of 18, we presume that a child has assumed critical decision-making. And what is required by the conduct of a government official is conduct that's specifically aimed at aimed at a constitutional violation and not a particular right. Because we have that present here, the city of Gutenberg, it was foreseeable that a constitutional violation would occur, and it was occurring outside of a high school where students were coming and going, and many 17 years old, Your Honors. That's exactly why the contours of this right are directly defined, only applying to children who have not assumed critical decision-making and only to conduct that's aimed directly at that particular relationship between parent and child. Thank you, Your Honors.
You may proceed when ready.
Madam Chief Justice, may it please the court. My name is Maseret Rahman, and I too represent the petitioners, Mr. and Mrs. Fitzgerald, the parents of Dorian Fitzgerald, their deceased son. Your Honors, I will address the second issue, demonstrating that the city's failure to train the permit officer where the need for training was obvious constitutes deliberate indifference, and therefore, a finding of qualified immunity afforded to the permit officer does not preclude municipal liability. Your Honors, petitioner respectfully requests this court to reverse the decision of the 14th Circuit in favor of the petitioners for the following three reasons. First, under a failure to train claim, the only consideration is whether a right is violated, not if that right is clearly established. Second, the city's failure to train the permit officer constitutes deliberate indifference because the need for training was obvious and was therefore the moving force behind the Fitzgerald's constitutional deprivation.
I have a hard time with that. I know you need to get your third point, but, you know, I don't know how you you've got busy city officials. They've got a lot of work to do and these permits are coming through. And so, yeah, maybe there was a red flag, but I don't see how, the approval of both permits, shocks the conscience. Is that what we need to decide here? And if so, help us.
Your Honor, the standard here today is deliberate indifference. Now, this court in City of Canton versus Harris held that where a municipality fails to train an employee, when that need for training is so obvious and failure to do so amounts to deliberate indifference. That was then reinforced by this court in Connick versus Thompson, when this court held that training is particularly necessary when an employee's discretionary act may give rise to a constitutional harm. Now, Your Honors, we acknowledge—
Is that what Connick said? I mean, I have a kind of issue here that, I mean, do y'all think, I called it maybe an inarticulately a boneheaded decision earlier, but do you agree that the decision by Ms. Bradbury was an obviously bad decision?
Yes, Your Honor.
Okay, I think that's right? But do you need training to tell people not to make obviously bad decisions? Like, are there, do you ever need training to tell people not to commit intentional torts?
Your Honor, here training is particularly necessary because of the fact that the city granted broad discretion to this permit officer without providing any training on when to use and how to use that broad discretion when facing situations that deal with an injury or harm that could give rise to a constitutional deprivation. That's exactly what we have in this case as alleged in the record. Now, Your Honors, we acknowledge deliberate indifference is an incredibly high standard, but Your Honors, we've met that standard today by demonstrating that where the need for training was obvious and the city's failure to do so amounts to deliberate indifference. That's reinforced by the Seventh Circuit in Burton versus Downey, where that circuit held that the subjective element of deliberate indifference requires that the official knew of and disregarded an obvious risk to an individual's health and safety. Now, one of the factors we look to under deliberate indifference is when that deliberate indifference amounts to a highly predictable constitutional deprivation. And highly predictable and foreseeability is a fact-based inquiry, as recognized by this court in Brasal versus Hagen. So because it's a fact-based inquiry, I want to walk this court through exactly what we have in the record, demonstrating how the municipality's failure to train that permit officer constitutes deliberate indifference. Your Honors, the city was on notice of the prior instances of physical, violent altercations between the moms and between the dads. That's evidenced throughout the record. I want to point this court to page 6, where it says that there were violent clashes between the moms and the dads. I then want to address the fact that in Justice Potter's dissent on page 20 of the record, Justice Potter acknowledges at least one instance of a physical altercation that occurred between the moms and the dads outside of a public library.
Is that sufficiently close enough for us to say that the official would have known that a student or a minor would have been, or an 18-year-old even, would have been caught up between the parents?
Absolutely, Your Honor. And it's for this sole reason we know that because the permit officer granted these permits from the moms and the dads to occur directly across Pensy High School concurrently, the same day, time, and location. As soon as students were being dismissed for the day, right next to the school buses where students would go to in order to get home. Now, what's important to recognize in the record is that the permit officer was on notice of the potential for violence because in their permit, the moms expressly stated to the permit officer of previous instances of physical altercations on page 33, Exhibit D. That demonstrates that the permit officer was on notice, but the question begs about the municipality being on notice. Then I want to direct this court to the fact that the very reason that the city enacted a permitting policy, as evidenced on Exhibit H, page 38 of the record, is because the city knew of the previous violent altercations that occurred between the moms and the dads. Now here, the permit officer granted these permits for protesting to
Clarifying question. The city enacted a policy in specific response to this specific clash? And because that policy wasn't perfect, they're deliberately indifferent?
No, Your Honor, they're deliberately indifferent because they fail to train. And now, Your Honors, this court in Oklahoma City versus Tuttle held that a municipality's failure to train an employee rises to the level of an official municipal policy. That's where we get deliberate indifference from, because the need for training was so obvious due to the sphere of violence that occurred between these two warring factions, the moms and the dads, who demonstrate a history of violent altercations. Now, because foreseeability is a fact-based inquiry, when we consider the fact that this occurred directly across Pensy High School, we're adding gasoline to the fire. We know the history of physical altercations that occurred between the moms and the dads, yet the permit officer, absent training from the municipality, granted these permits to occur. Now, the moms expressly stated in their permit for protesting, that part of the reason they would like to protest is in order to hand out banned books to students. Inherently, the moms are enticing students to approach their table. That's exactly what Dorian Fitzgerald did alongside other students from his high school. He approached the mom's table to get banned books and to peruse those books. Violence quickly ensued, violence that the city was on notice for. Now, Your Honors, we're not asking this court to recognize that the proper protocol would have been to deny these permits or protesting outright. We don't want to implicate the First Amendment by demonstrating that the moms and dads should not have been able to protest. But what we're simply asking for practically is that the proper training should have reflected to the permit officer that in situations where there is a constitutional risk of an injury, then the proper protocol is separation or supervision. Allow for separation and proximity between the moms and dads to ensure that we could mitigate the risk of harm, or provide supervision by using city resources to provide police to these protests to ensure that no student would be implicated in the harm. By granting these permits to occur outside of a high school, well, now we're putting at risk students between the ages of 14 to 18 for their rights to be implicated, giving rise to a constitutional deprivation. Now, Your Honors, for moving force, the Third Circuit in Thomas versus Cumberland County held that mere evidence that violence could occur or a constitutional deprivation could occur is enough for a plaintiff to recover. That's what we have here. The city and the permit officer was on notice that a constitutional deprivation could occur. And absent any training, the municipality should be held liable. That goes directly into the Second Circuit's holding in Outlaw versus City of Hartford, where the Second Circuit recognized that a municipality may be held liable for deliberate indifference when the employee's conduct is the moving force. Here, as the record indicates, it is clearly the moving force. Absent any training, the permit officer granted these protest permits to occur concurrently outside of a high school, implicating the rights of any student between the ages of 14 to 18.
You said a couple times that there's an absence of any training, but if we look at, your own exhibit I mean, is that policy not training? Like how are government employees trained but for policy?
Your Honor, that exhibit does not demonstrate training. It just demonstrates the guidelines. Those guidelines were provided to the permit officer, but required training in order to demonstrate that she knew exactly what to do when faced in situations where we have two warring factions. But absent that training, the permit officer used her broad discretion to grant both of these permits. If the city had practically trained her, specifically pointing to the fact that in the event that there is an endangerment to the safety of surrounding individuals, then the proper protocol would have been to substantively or non-substantively deny the protest permit. Now, denial of that protest doesn't demonstrate a substantive denial, but rather a procedural denial in order to mitigate the risk of harm. Your Honors, that takes me into the final reason this court should reverse in favor of the petitioners, because failing to distinguish between qualified immunity and municipal liability undermines this court's holding in Monell and risks incentivizing dangerous gaps in training. Your Honor, Monell was clear that municipalities are not entitled to the same protections afforded to individual officers. The justification behind that is immunity is tied with damages. We don't want individual officers to be burdened with financial liability. By holding municipalities liable for their failure to train and their deliberate indifference, what we're doing is we're tying that municipality's financial liability with their institutional responsibility, ensuring that we aren't depriving individuals of their constitutional rights. Thank you.
Thank you.
Thank you, Chief Justice, and may it please the court. My name is Will Sosna, and I, along with my co-counsel Smith Hart, represent the respondent in this case, the City of Gutenberg. This case is about determining the proper limits of substantive due process. Mr. Hart will explain that qualified immunity for the city permit officer, Charlotte Bradbury, precludes a finding of municipal liability for failure to train. But first, I will explain that the petitioner's asserted right to companionship with their adult son does not afford them a constitutional claim for relief in this case. This court should affirm the ruling of the 14th Circuit below for two reasons. First, there is no substantive due process right to companionship with an adult son or daughter. And second, any right to companionship with a child must end when the child reaches the legal age of majority. The Fitzgeralds in this case claim a substantive right under the Due Process Clause of the 14th Amendment. As the 14th Circuit below noted on page 9 of the record, this court has been clear that any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty.
All right, some questions on that point. Can you define for us like loss of consortium generally? Not trying to put you on the spot, but
Well, that is a tort remedy, Your Honor, that does give plaintiffs a cause of action when they have been deprived of the companionship of a family member. But that is a state law tort claim, not a.
Isn't that also a common law tort claim for loss of consortium for companionship services and of a kid, and you would agree that existed in England, that existed in early practice in the United States?
Yes, Your Honor.
So let's assume that's at least a remedy that has been recognized for a long time. You'd agree that remedy is deeply rooted in our history.
It does exist and has existed in tort law, Your Honor. Yes.
All right. Well, what does that do for our inquiry? I mean, does that not mean that this is a right that we can recognize?
Well, no, Your Honor. The question here is whether there is a constitutional claim under 42 U.S.C. Section 1983. The fact that there might also be a tort claim somewhere in this case does not mean that there is also a constitutional claim. And the overwhelming weight of authority in this country has applied this test and refused to recognize a right to companionship between a parent and an adult child. The 1st, 3rd, 7th, 11th, 14th below, as well as the D.C. Circuit, have each addressed this issue and refused to extend substantive due process protections to the relationship between a parent and an adult child. And critically, this court has never recognized this right.
I just think the hard line you want us to draw at age 18 is too much. Like, I mean, there's so many areas in which society and history and tradition, recognizes that, the parent-child relationship needs to extend past age 18. And I mean, currently, the law allows children to stay on their parents' insurance until age 26, and you can claim a dependent child up until the age of 21. So I'm just a little worried about this sharp line you want us to draw. Can you make me feel better about that?
Yes, Your Honor. The line is not necessarily at age 18. It is at the age of majority as determined by the legislature. As to the federal law point, federal law does defer to state law in setting the age of majority in multiple contexts. Two examples would be the IDEA Act as well as HIPAA, which involve parental decision-making in the lives of a child as it relates to education and healthcare. And in both of those contexts, a parent's right to make those decisions for a child automatically ends when the child reaches the age of majority in the state in which that child lives.
But I mean, this kid, is still living at home. He's, still, I assume his mom's making him breakfast in the morning, and, he's riding the bus to school. I mean, I just, this automatic transition that you want us to impose just troubles me.
Certainly, Your Honor. Dorian Fitzgerald may still have been living at home, but the fact that he had reached the age of majority meant that was a choice for him. He could have moved out of his parents' house if he wanted to drop out of Pensy High School, his parents would have been powerless to stop him.
All right, assume that we're not going to buy that, right? If you want us to draw a cleaner line, and if the Bill of Rights and the 14th Amendment is designed to regulate government conduct, right? Wouldn't a better bright line be students get protected, right? When they're wards of the city of Gutenberg, right? Like, why shouldn't that be our inquiry so that we can regulate the conduct of the city and the administrators?
Your Honor, the framing of this right is important here. The right that this court has recognized to the parental right, the companionship, care, custody, and management of children A has uniformly been applied to minor children, but as well, this is a right that allows parents to make decisions for their children without regard to the child's own wishes. In Meyer versus Nebraska, this court invalidated a state law mandating instruction in English. Later on, in Wisconsin versus Yoder, as well as Pierce versus Society of Sisters, this court invalidated state laws mandating public education. And the rationale in those cases is that parents have a right to make that decision for the child. It doesn't matter if the child would rather attend a public school or would rather not learn a foreign language. The parent has a right to make that decision for them. This cannot extend into adulthood. The very nature of this right is that once a child has reached the age of majority, it can no longer be exercised.
You know, I honestly don't think I agree with that. Then this may be a red herring, but I mean, I'm the oldest one on this panel, and I mean, at some point, parents need children to be making decisions to help them, and so, I mean, in so many ways, that relationship is fundamental to who we are as people and how we define family, and so, I'm just having a hard time with saying once a child is 18 or even 21 there's no protection from the government.
Certainly, Your Honor, the relationship itself is fundamental, but from a legal standpoint, this relationship does end. And this is a unique substantive due process right in as far as it applies to a relationship that does not last forever. And once again, this is a right of parents to make decisions for a child. If Dorian Fitzgerald wanted to drop out of Pensy High School, he could have done that, and his parents could no longer have exercised their rights under Pierce and Yoder to control where or whether he goes to school.
Where are you getting the idea that the right is limited to making decisions? Your colleagues on the other side seem to have defined it more broadly and, in, I think, more loftier goals, and you just seem to be narrowing it. Where does that come from?
Your Honor, the uniform application of this right in this court's precedent in Meyer, Yoder, and Pierce and other cases has been to protect the right of parents. It's been to protect parental decision-making and preventing the state from interfering in that. So the nature of this right is that once a child is able, legally speaking, to make these decisions for himself or herself, this right can no longer be exercised at that point because the child has the right to refuse. Dorian Fitzgerald may have chosen to still live with his parents, but he had the right to leave and they could not have stopped him. They could no longer have exercised this right to make decisions for him. The asserted right in this case, a right to companionship with an adult child, is also readily distinguishable from the many other substantive rights that this court has recognized. A review of this court's substantive due process cases reveals an overarching theme of personal choice. In cases like Obergefell versus Hodges, Loving versus Virginia, Zablocki versus Red Hill, protects a right to choose who to marry. Griswold versus Connecticut, Skinner versus Oklahoma, as well as Eisenstadt versus Baird, protects the right to choose when or if to have children. Moore versus City of East Cleveland protects the right to choose who to live with, as well as how to define one's family unit. The right that the Fitzgeralds assert in this case is not about choice. It is about the company of their son. And not only has this court not recognized a constitutional right of this sort, earlier this year in Department of State versus Munoz, this court rejected that sort of analysis. In the Munoz case, this court held that while there is a fundamental right to marry, there is not a corresponding fundamental right to reside in the United States with a non-citizen spouse. This stands for the principle that there is no company, companionship, or association component to fundamental rights under the Due Process Clause of the 14th Amendment. And when that analysis is applied to this case, once Dorian Fitzgerald had reached the age of majority, his parents no longer had a right to make these critical decisions for him because he had assumed the responsibility to make these decisions for himself. There's, in addition, an important distinction to be made.
And there's no real factual development on that. I mean, he's living at home, and so we can assume he made that choice, and he's stuck with the consequences.
Well, Your Honor, the dispositive fact in this case is found on page 5 of the record in footnote 1, which is that in the state of Genovia, 18 is the age of majority, and Dorian Fitzgerald had reached that point. So this right no longer could have been exercised as to him. There is, in addition, an important distinction between assuming responsibility for something and exercising that responsibility.
So it sounds like the scope of this right may vary from state to state depending on state law. If a state passed a law akin to common sense, it says like, you know, if you live at home, follow your parents' rules. If you're still in school, follow what your parents' rules. Are you saying there would be a different result in that case?
States retain the ability to create a cause of action for the parents in the Fitzgerald's position. But the question here is whether the Constitution creates.
Yeah, I'm asking if you really are agreeing that states could change the scope of this federal right by adjustments to the age of majority or tinkering with that.
It would not be an adjustment to the existing right, Your Honor. It would be a separate cause of action that the state could create. There's important separation of powers principles there. Statutory rights are important and do exist, and states retain the authority to create causes of action for parents in the Fitzgerald's position. But in this case, the Fitzgeralds seek the recognition of a right that has never been recognized by this court, which the overwhelming majority of circuits have refused to recognize, and whose recognition today would violate the purpose of this right, which is to allow parents to make decisions for their children. These reasons we ask the court to affirm. Thank you.
Thank you, Chief Justice. May it please the court, my name is Smith Hart, and I also represent the respondent, the City of Gutenberg. My co-counsel, Mr. Sosna, has explained why there is no substantive due process right to companionship with an adult son or daughter. I will explain why, even if this court decides to establish that right here today, the City of Gutenberg cannot be liable for a failure to train. This case is about connecting municipal liability to municipal fault. The question that this court certified for review on page 3 of the record is whether the 14th Circuit's holding granting qualified immunity to Charlotte Bradbury precludes liability for the City of Gutenberg. And the answer to that question is yes, for 2 reasons. First, because causation in failure to train claims requires a high degree of foreseeability. And second, because the analyses for failure to train claims and for qualified immunity consider functionally identical questions. This court said in in Monell versus Department of Social Services that it was important that we hold municipalities liable when they cause a constitutional violation. And as a matter of policy, this standard makes a lot of sense. It strikes the balance between a too narrow standard that would make recovery under 1983 almost impossible and an overbroad standard that would hold municipalities liable for any injury within their borders, constitutional or otherwise. And so again, from a policy perspective, this standard strikes a reasonable middle ground between 2 extremes.
I don't know. I mean, don't we, I mean, I think everybody probably agrees that Ms. Bradbury, you know, shouldn't lose her house, you know, to pay for this claim from this family. But I mean, having municipal liability is probably a pretty good way to spread the risk, isn't it?
Your Honor, municipal liability is appropriate when a city does cause a violation of constitutional rights, absolutely. But in cases where the injury is too far removed from the policy in question, then in those cases, like municipal liability cases that this court has described in Bryant County versus Brown, as this court said, rigid standards or rather rigorous standards of culpability and causation are required.
But aren't you really asking for a factual analysis? And, you know, that's after all the other side's asking for is to remand for factual development. And so, I mean, if we're deciding these cases on a spectrum, then why wouldn't that be best done by a jury?
Your Honor, the Petitioners are the master of their complaint. To the extent that there are not facts available in the record, it was because the petitioners under 12b6 and Ashcroft versus Iqbal have failed to plead sufficient facts to make a plausible claim.
Yeah, I mean, they want to do discovery and develop the record. And
Yes, Your Honor.
you're saying no.
Despite the petitioner's claim that this is a direct violation by the city, petitioner's theory of liability rests on a broad but-for view of causation that was warned against by this court in Oklahoma City versus Tuttle. And their claim that this is a direct constitutional violation caused by a city policy is rebutted by the fact that a large, probably half of their argument was taken up by simply attempting to describe this attenuated chain of causation. And so in a situation as described by Bryant County versus Brown, where a city official comes into regular contact with the risk of a specific constitutional right being violated, then that violation is plainly foreseeable. For example, if
Your repeated invocation of our precedent is somewhat perplexing because what I haven't heard is Owen versus Independence. I think we would have to overrule that in order to rule in your favor. That has a pretty simple rule. Cities don't get qualified immunity. Your argument is creative, but it seems in direct tension with that simple rule. Do we need to overrule Owen?
Your Honor, we are not asking this court to overrule Owen versus Independence, and we are not asking this court to develop any new precedent or to create any new rules. That brings me to my second point, that the analysis for qualified immunity already considers a functionally identical question to one of the essential elements in a failure to train case. And as petitioner pointed out many times, the essential element for them is the existence of a plainly obvious risk to a specific constitutional right. And in the 14th Circuit's holding on page 42 of the record, they granted Charlotte Bradbury qualified immunity because the right itself, A, was not clearly established, but also B, because there was no plainly obvious risk of a constitutional right. And that holding, which petitioners had an opportunity to appeal and have failed to do so, has on the same facts with the same risk to the same right by the same official, has already been held that no such plainly obvious risk to that constitutional right existed.
Okay, well, let me ask you a sort of related question to that. So let's assume that there is a constitutional violation under the same fact pattern, but just has a different home, right? Like Dorian's first person rights for substantive due process were violated under the state created danger test, right? Let's assume that that's the case, right? Plaintiffs didn't plead that. That's not necessarily before us, but assuming that that right exists, doesn't the city need to train with respect to that right? And their failure to train in that case, right, would lead to the same conduct and I think would defeat your qualified immunity argument, no?
So as you said, petitioners did not plead the state created danger claim, but assuming that they did.
And assuming that that's a clearly established right, right?
That would be the right to be free from state created danger.
For Dorian, yes.
For Dorian. Then in that case, there would still not be a necessity for the city to train Charlotte Bradbury to prevent the violation of that right because the risk to it was not plainly obvious in this case. And so that question also assumes that the qualified immunity analysis used by the city in the plainly obvious sense can be applied here. And because there is not foreseeability for a city that granting a permit to exercise First Amendment rights would have the tertiary consequence of violating a substantive due.
I'm not sure I agree with you. Why wasn't this plainly obvious? I mean, it's a protest with two groups who have had prior conflicts directly across the street from a school. Seems kind of obvious to me.
Your Honor, as described in page 24 of the record, there were threats and inflammatory rhetoric. On page 32 of the record, one group prevented the other from entering a library. And on page 34 of the record, it is described as physical altercations and name calling. And none of this rises to the level that would be expected to violate the substantive due process right in the manner that it did. And further, even had that been the case, failure to foresee generalized danger, especially criminal violence, is at worst negligence. And this court has held in Daniels versus Williams that negligence is categorically barred as a constitutional claim. And
You know, in the mother's permit, excuse me for interrupting you. I mean, they say police presence would help prevent a violent encounter. Like, what else did it need to say?
Your Honor, police presence would prevent many different violent encounters, but the absence of police for a given violent injury does not create a constitutional claim under Section 1983. This court in Monell versus Department of Social Services, the foundational municipal liability case, considered that Congress expressly rejected an amendment to 1983 that would have held cities liable for general damage caused by riots within their borders, and rejected that because it was likely unconstitutional. And so, again, despite the fact that, say, a First Amendment violation, if Charlotte Bradbury had committed content-based discrimination and had granted one permit and denied another because of the way she felt about the group's viewpoints, would have been a plainly obvious and foreseeable risk to that constitutional right, assuming that the city policymakers could have foreseen the, again, tertiary consequence of granting such a First Amendment right permit would be the broad but-for view of causation that is warned against by Oklahoma City versus Tuttle, one of this court's precedents.
Can we at least agree that Ms. Bradbury's action was negligence?
Your Honor,
Negligent? Like, I mean, you said obviously we got to show more than that, but can we at least agree that what she did was negligent?
to use your words with petitioner's honors, Your Honor, with the benefit of hindsight, it is easy to say that Ms. Bradbury made a boneheaded move. But this court said that in Canton versus Harris.
Sure. All right. So another question, follow up on that. So do you agree with them that the standard is deliberate indifference?
Yes, Your Honor.
Okay. So how are we consistent with, Rule 12, and then, down the line, Rule 56, the Seventh Amendment? How can we possibly parse the difference between negligent action and deliberately indifferent action as a matter of law? That seems totally incoherent.
Yes, Your Honor. So foreseeability, failure to foresee generalized danger, particularly at the hands of private parties, is negligence, whereas failure to foresee a specific risk to a constitutional right, a specific constitutional right that a city official is faced with on a regular basis, rises to deliberate indifference.
But again, that's the same sort of problem, but in the proximate cause issue where, again, that's not generally a question as a matter of law. Like how can we make that on this limited record at this time as a matter of law without usurping the role of the fact finder?
Well, as a matter of law, it's important to establish the legal cause of the injury, and the limiting principle for proximate cause rather than a broad but-for view is foreseeability. And so in cases like these, where you have a lack of action on the part of the city leading to a failure from Bradbury to deny a permit, leading to two groups getting together whose primary purpose, as stated on page 32 of the record, is the protection and welfare of children, and then those groups surprisingly leading to criminal private violence, as well as the voluntary participation of Dorian in that event, and that long attenuated chain of causation, the foreseeability required for each additional link in the chain is simply not present with the facts pleaded by the plaintiff here today. The plaintiffs have asserted—
You think no reasonable jury could find otherwise?
No, Your Honor. And the plaintiffs have pleaded a right here today. Their claim is based on a right that does not exist, that was not damaged by the city, that was not foreseeable, and has already been precluded by the lack of an essential element in their claim by the 14th Circuit's holding, which they failed to appeal. And so because the 14th Circuit made that analysis to the same right, the same risk to that right from the same official on the same facts, that analysis should apply to the claim against the city of Gutenberg, and we respectfully ask that the motion to dismiss is affirmed. Thank you very much.
Thank you.
May it please the court. 2 brief points on rebuttal. First, this court should reverse because the right to companionship extends until a child assumes critical decision-making responsibility. Justice Martin, you highlighted the exact problem with the respondent's test. It is arbitrary and unfair in nature. Your Honor, you asked, are there any factual indications? And why does this automatic rule trouble me? It should, because the ever-changing family dynamic that we have present here warrants a reversal. There is no indication in the record that Dorian Fitzgerald had assumed critical decision-making. But more importantly, Your Honors, this case, at a minimum, should be remanded for that factual determination to be made here. Further, Your Honors, Madam Chief Justice, you asked, what warrants a narrow application of this right? None. This court's precedent makes clear that when we are dealing with the expansion of a substantive due process right, so long as it is tied to a currently existing right and a particular circumstances present per Stanley versus Illinois, that right may be extended without infringing beyond the bounds of what is constitutionally permissible, Your Honors. Turning to the second reason this court should still reverse. When we are dealing with municipal liability, qualified immunity does not extend to the city of Gutenberg. Justice Guedemeyer, when we are dealing with the questions that you asked opposing counsel as to whether this is a tertiary or primary consequence, this was a primary consequence of us granting a permit officer broad discretion to allow for counter protesters that entice students with books right outside of a high school. Your Honors highlighted, was this risk obvious, and was a constitutional violation evident? It is clear from pages 6, 7, 20, 25, and 27 of the record on a motion to dismiss that evidence of violence is read in favor of the light most favorable to the non-moving party. The violent clashes and prior physical altercations between the groups renders this foreseeable to the city of Gutenberg. Thank you.
Thank you.
Final round.